I think I received a number of filings that you filed 4 filings this morning with the clerk of court. I had a chance to briefly review them. So before we proceed, would you like to have an attorney appointed to represent you?
I represent myself.
Okay, so we'll address that in a moment. Mr. Helling, I think that I saw that Judge Bishop had notes in this case about having this case set for trial if there's no movement in this case, because I understand, Ms. Williams, you don't intend on entering a plea.
I'm sorry, I'm 75% deaf. I almost didn't hear any of that.
Sure, so I'll try to speak a little bit louder. Ms. Williams, my intent today is to set this case for a trial.
You're going to address the jurisdiction challenge?
Yeah, it's legally insufficient. It's denied. We have personal jurisdiction over you because you live in the state of Florida and you are operating allegedly a motor vehicle on the streets or highways of Union County. So we have personal jurisdiction over you. That's going to bring me to the next point, which is you indicated that you're pro se and that you do not intend on hiring or having an attorney represent you. Is that correct?
From this point on, I'm invoking constitutional law in this courtroom.
Okay, I intend to follow the U.S. and Florida Constitution, so we're on good standing.
And reserve all of my rights. And at this moment, I'm going to choose to invoke my right to remain silent. And because it's a criminal court, my silence cannot be construed as consent or guilt.
Okay, so here's what I'm going to do is I'm going to ask you some questions about whether or not you understand how to represent yourself. If you choose to remain silent, I will appoint an attorney because you've refused to answer my questions.
I object that.
Okay.
I object. Excuse me.
All right. So have you ever studied law?
Yes, for the last 4 years.
Have you ever represented yourself in a criminal action before?
I know, I stay out of trouble.
So is that no?
No, I never, does that matter?
It does, because it goes to your knowledge and ability to represent yourself as well as to understand and appreciate.
I'm very competent. I'm not to be presumed ignorant.
Okay. Do you understand each of the charges against you?
No, I do not.
Okay. So you are charged with 1 count of driving while license is suspended or revoked, which
what
means...
was the probable cause to pull me over?
So that's not what I'm asking you right now.
That has to be put on the record before any proceedings.
Okay, well,
by law.
So you were charged with driving while your license was suspended or revoked.
I wasn't driving. I was wrongly accused of driving.
Before we even press play on this courtroom footage, you need to understand exactly what kind of case you're about to witness, because this isn't just a routine traffic matter. This is a full-blown collision between internet law fantasy and real-world consequences. Today's defendant walks into court armed with constitutional buzzwords, sovereign citizen-style arguments, and a belief that if she says the right magic phrases, jurisdiction, traveling, I don't consent, the entire justice system will just shut down around her. What makes this case especially wild is the contradiction at the heart of it. She repeatedly invokes her right to remain silent, while refusing to stop talking. She claims deep legal knowledge, yet can't explain the most basic elements of the charges she's facing. And as you'll see, the judge bends over backwards to give her every warning, every explanation, every opportunity to protect herself, only for her to reject all of it in real time. This case is a masterclass in what happens when confidence replaces competence, and ideology replaces reality. Stick with this video because what starts as irritating quickly escalates into jaw-dropping legal self-destruction.
I invoked and clearly, would you like to see?
I'm gonna be talking for a little bit, and so I would like you to listen to my questions. This isn't a chance for you to try your case. This is for me to decide whether or not you're competent to represent yourself at trial. Okay?
I am.
Well, I will make that decision. So you were charged with 1 count of driving while license suspended, 1 count of resisting an officer without violence, and 1 count of failure to register a motor vehicle. Do you know the maximum penalty for each charge?
No, I don't.
Are you familiar with the legal elements of each charge?
No, I don't recognize policy. I don't
That's not
recognize
my question, which is...
administrative law or statutory law.
Well, you may not recognize it, but it will be imposed on you, and if you are found guilty, the judge will impose a sentence whether or not you recognize it or not. Do you understand that?
If you force jurisdiction where there is none, you'll be open doors to impeachment and lawsuits.
Okay. Well, I probably won't be the judge trying the case, so that's okay with me.
Your Honor, if I may, I think that Judge Bishop has gone over these with her already, and she has once again maintained her
Sure.
proceed pro se.
I think though, if I'm setting for trial, I think just to be safe for every stage, I'm just going to go over.
I'm going to say this is case management. It will go to pretrial next month, and then trial after that. So I think we're one step away from setting it full trial.
I'm going to fire any judge, any attorney that's been appointed to me. So
I guess, Mr. Salter, if I set this for trial, would you be willing to be standby counsel just in case?
I think I would need to be, yes, sir.
Yes.
He's fired.
Well, you don't get to fire your standby counsel.
I do not consent to that.
Well, that's the thing about this is that
I have a right to represent myself. I've made it clear.
You have the right to represent yourself.
Yes.
But also the other part is that you have to be fully aware of all the risks that come with it.
I am. I'm willing to take any risk.
Okay. I'll just put it this way, having read your legal filings as well as the arrest report, I think you fundamentally misunderstand the laws and Constitution.
I am not. The Amish community has well kept up that right.
I'll just put it this way, I don't see many Amish people driving cars and using
you're
phones.
looking at one.
This moment right here is where things start going off the rails fast. Notice what she's doing. She's invoking the Fifth Amendment, her right to remain silent, while simultaneously continuing to argue, object, and lecture the court. That's not how that right works. You don't get to selectively stay silent while still controlling the narrative. The judge is actually being extremely patient here, explaining that he needs to ask specific questions to determine whether she's competent to represent herself. That's not a power trip. That's a constitutional safeguard meant to protect defendants from hurting themselves. But instead of answering simple yes or no questions, she pivots into buzzwords like constitutional law and reserving rights, which sound impressive online but mean nothing in this context. And here's the irony. By refusing to answer, she's actually pushing the court toward appointing counsel against her wishes. This is the exact opposite of what she thinks she's accomplishing.
Your Honor, we don't really have a trial week next month, so we'll just if you could put this on pre-trial conference for the next month, Judge Bishop
when is our pre-trial conference?
June 10th.
All right. So it's the same day as case management?
Yes, Your Honor. We only have one misdemeanor court date.
All right. So I'll put your case on for pre-trial conference. Be aware that you are charged with driving while license suspended and resisting an officer. Both of those are first-degree misdemeanors. Maximum punishment of those consecutively would be up to 2 years in the county jail. Failure to register a motor vehicle, that's a second-degree misdemeanor, which is punishable after 60 days in jail. So you could find yourself spending up to 2 years and 60 days in jail on these charges. Do you understand that?
No, I don't. But
okay. So here's what happens is if you're found guilty, because what the state's required to prove are the essential elements of each charge.
I have all that.
The essential elements of driving while license suspended is that you were operating a motor vehicle on the streets or highways of Florida while your license or privilege was revoked or suspended.
I still don't
Whether or not you were
cause.
traveling, flying, or whatever you want to describe it, if you were in a car and that car was moving and you were operating that car and your license was suspended, then the jury would be instructed that all essential elements have been proven and they should find you guilty. Likewise, resisting an officer means that you resisted, obstructed, opposed an officer in the lawful execution of a duty, but you did not offer violence during that. If they find that you committed that offense, you would be found guilty and could be punished by up to a year in the county jail. So with that, you wish to have this set for trial?
No, I do not.
Okay.
But I wish to have it dismissed.
Your options today are to enter a plea or set it for trial.
You make the call.
Okay.
I'm not going with any plea, so.
Okay, then we'll set it for trial. So that's how the case will be resolved. We'll set you on for June 10th for pretrial conference. Please sign notice and we'll see you then.
Thank you.
This is one of the most common red flags judges see, and they hear it all the time. I've studied law for years. Studied where? Under whom? In what capacity? Watching YouTube videos and reading Facebook threads does not equal legal education. And the judge's questions here are extremely basic for a reason. He's not quizzing her to embarrass her. He's establishing whether she understands the charges, the risks, and the procedures. And every answer she gives actually hurts her position. She admits she doesn't understand the charges. She doesn't know the penalties. She doesn't know the elements of the offenses. Yet she insists she's fully competent. That contradiction matters. Courts take self-representation seriously, but it comes with responsibility. Confidence alone doesn't meet the standard. And the more she talks, the clearer it becomes that she's not just unprepared. She's fundamentally misunderstanding how the legal system works.
May I address the court, please?
That's why your case was called.
Article 6, Clause 2 of the United States Constitution says, "This Constitution and the laws of the United States, which shall be made in pursuance thereof, shall be the supreme law of the land, and the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding." This means no state law, no local ordinance, and no traffic code can override the the supreme authority of the United States Constitution, especially when it comes to the fundamental liberties of the people. I am here today as a special appearance, not because I committed a crime, but because I exercise a federally protected, clearly established constitutional right, which is the 14th Amendment right to travel in my private automobile without government permission or interference.
All right, stop. I don't have time to deal with this, and I'm not going to listen to this. Everything you're saying is absolute nonsense.
It's very true.
Stop talking. Don't talk. Everything you read about, when you read from the Constitution, yes, you read that correctly. Your interpretation and everything you think you're doing is absolutely wrong. The writ of prohibition that you filed in the First District Court of Appeal was dismissed yesterday, and we received that order, okay? I don't know what you think you're going to get by filing a writ of prohibition in the United States Supreme Court. If they even choose to answer that, we'll wait to see if there's an answer to that.
I will.
All of your claims are absolute nonsense, and I don't have time to deal with them. You were charged with driving on a suspended license, resisting an officer without violence, and failure to register a motor vehicle. Stop. Don't talk. The state attorneys offer to you as an adjudication of guilt a $100 fine, court cost, and cost of prosecution.
Judge, to clarify that offer is no longer open.
That was the offer, okay? So there you go. The state attorney revoked the offer. Very, very good.
Here's where internet pseudo-law crashes straight into reality. The whole, "I wasn't driving, I was traveling" argument has been debunked in every courtroom across the country, thousands of times over. The law does not care what word you prefer. If you are seated behind the wheel of a moving vehicle and controlling it, you are driving, period. The judge even pauses the proceeding to make something very clear. This is not the trial. This is not her moment to argue facts. This is about whether she understands the process well enough to represent herself. And she doesn't. She keeps trying to litigate instead of listening. That's a dangerous mistake. Judges notice that. Jurors notice that. And when you ignore instructions this early, it sets the tone for how the rest of the case will go, and not in your favor.
This is pretrial conference. And I don't have time right now. I just don't. I have to end our docket today because I have another appointment to get to go through a Feretta hearing with you right now. But you have indicated previously that you want to represent yourself, and so far you have been representing yourself, and with that being all the state had previously been asking for, that's all we would have done anyway. Okay. So you're not going to like anything I'm going to do right now, okay? And you're probably not going to agree with it. If you want to file all the nonsense that you've written down on paper and file it with the clerk, you certainly can. And then you can appeal any decision that I make to determine whether or not I've acted within the laws of the state of Florida, okay? I'm going to temporarily, because I expect that you're probably going to want to represent yourself if that's what you want to do, but you do have the right to have a lawyer represent you, and it sounds like the state's going to turn a little harder toward a more severe punishment. I'm going to appoint Mr. Salter to represent you today. I want you to at least try to have a conversation with him. And if you don't do that, well, we'll deal with that later. I'm going to continue the pretrial conference to the July docket. And at that date, if you indicate to me that you want to represent yourself, then we'll have a FRERETA hearing on that date.
That's fair.
I'm not going to hear anything else from you today. I don't have time to deal with it.
I understand.
If there's something that you want to file, you can write until your hand bleeds on your paper. You certainly are free to do that, and you can file it. Whether it has any merit or not, I'll make decisions that I have jurisdiction to make, and then the appellate courts can make decisions about the jurisdiction, about the things they have jurisdiction to make, to include my decisions and my legal opinions. Okay? I'm not going to deal with all of this today. All right? Sign your notice to appear for July 15th, and I'm appointing Mr. Salter to represent you for today.
That's the last case on the docket.
This is a classic escalation tactic. When the legal argument fails, threaten lawsuits and impeachment. But notice how calmly the judge responds. He doesn't argue. He doesn't get emotional. He simply explains that whether or not she believes jurisdiction exists is irrelevant. The court has it, and the case will proceed. That's an important lesson for viewers watching at home. Courts don't operate on consent. They operate on law. You don't opt out of criminal jurisdiction by refusing to acknowledge it. And threatening future lawsuits doesn't intimidate judges. It just signals that the defendant is relying on ideology instead of substance. Every time she does this, she digs the hole deeper, because it reinforces the court's concern that she does not understand the process she's trying to control.
Your Honor, just for the record, I know that you appointed me to represent Ms. Williams the last time. She has not contacted me and has no interest in me representing her, so I'm going to sit there.
I understand that. And Ms. Williams, and I'm going to go through some things with Ms. Williams. I'm going to allow her some time to talk.
I can't hear you. You're going to have to speak up.
You need the hearing? We have hearing aids.
No, that's nasty, disgusting, dirty. You don't even...
All right. Well, I'm not going to shout. Ms. Williams, I'm not going to shout, okay?
You did the first time, so...
No, I didn't. I've never shouted at you.
Well, then do you have any other accommodations for handicapped people?
I have these hearing aids. They've been cleaned off and sanitized.
No, they're not. They've been cleaned off. They're not been replaced. I'm not putting something that's been in someone else's ear in my own.
You obviously can hear what I'm saying to you, correct?
Because you raised your voice a little.
Okay, thank you.
But I didn't hear that.
Let's keep our tone civil if we can. Can we do that?
Yes,
can we maintain
I can.
civility in our discussion? I'm going to allow you some time to talk.
I talk loud because I'm deaf.
This might be one of the strangest pivots in the entire hearing. Claiming Amish identity to avoid modern legal obligations while simultaneously operating a motor vehicle is not just inconsistent, it's self-defeating. The judge isn't mocking her here. He's pointing out an obvious factual contradiction. The Amish community is well documented for rejecting automobile use. You don't get to selectively adopt cultural identity when it's convenient and discard it when it's not. Courts look at behavior, not labels. And moments like this destroy credibility. Once credibility is gone, everything else becomes harder. Motions, testimony, arguments, all of it. This is the cost of trying to outsmart the system instead of understanding it.
Okay.
So I'm just stating the fact that we talked about that prior, or the very first case I was here, I couldn't hear. So
okay, we've had many conversations here on the record, and that hasn't been an issue before, but I'll do my best to speak up.
That's because you screamed at me last month, so, I didn't have no problem hearing that.
All
so,
right.
yeah, okay.
Ms. Williams, I didn't scream at you. Everybody in the world has seen the video you posted of our court proceedings.
Yep.
Here, okay, to include myself.
Only 600 something.
That's great. I have no problem with anything that I said in your case, so you do what you feel like you want to do.
The JQC had a problem with it.
It does appear, and I will say that it does appear that you properly requested through a public records request to get the recording of what we do here in court.
Yeah, I did.
And that's
Paid
what you
for it and
published.
everything.
I want to caution you and anyone who's with you that if you privately record anything in this court...
I ain't privately recording anything.
Let me finish talking. Stop interrupting me.
I'm just proving it.
Because you need to hear this. If you privately record anything in this courtroom, then you'll be in violation of the administrative order that prohibits such recordings, and I will proceed with contempt proceedings. Do you understand?
As long as they work, I'm good.
that camera's working, that camera's working, everything's being recorded. You request away under Chapter 119 for all the public records you want. I have no problem with anything I say here on the record, okay? All right, I understand all of the things that you filed. I want to make it clear for the record that there are several things that you filed that I have determined are not legally cognizable.
Some of them were just, just letters not meant to be.
Okay.
So,
I have stricken those things that I found to be legally not cognizable. What
exactly are those things?
Again, you know how to do a public records request, so you can request your court file and get a copy of the things. Okay. Stop interrupting me when I'm talking. All right. I entered an order striking several of the pleadings. You did file one where you objected to the forced appointment of the public defender. And that, I believe, does legally trigger a Ferretta hearing. And so I did set today to have a Ferretta hearing with you, to go through the colloquy with you, to allow you to represent yourself if I find that you're doing that knowingly, intelligently, and voluntarily. Do you understand that?
We first have to establish jurisdiction on the record before we can do that.
No, jurisdiction is, I do not have to go, that's the...
You have to have both jurisdictions before you can proceed. You don't have either one of them. Neither one of them have been proven on the record.
All right. What is it that you think? I'm going to entertain you for
I already said them to you.
What is it that you think? Well,
I have a whole list.
Say it here on the record. What is it that you think compromises this court's jurisdiction right now?
Is constitutional violations. This court clearly does not honor the Constitution. Okay. So therefore, it's not a federal court. It needs to be moved to a federal court. Because my rights were violated from the start. The initial traffic stop was unlawful.
Your charge of driving on a suspended license, resisting an officer without violence, and failing to register a motor vehicle, all violations of Florida statute, you say
Florida statute.
You say
I was exercising federal protected rights that Florida has to honor as well.
Ms. Williams, this is the nonsense part I'm talking about.